Hello, I'm Paterno Makel. This is Rappler Talk. July 12, 2019 is the third anniversary of the Philippines' legal victory against China over the South China Sea. To help us mark this event, we have with us today the Philippines' lead counsel against China, Mr. Paul Reichler, who's joining us from West Virginia via Skype. Thank you for joining us, Paul.
I'm very happy to be here with you, Paterno.
Paul, it's been 3 years since the arbitral award, and it's happening at an interesting time for the Philippines because recently a Filipino fishing boat was sunk by a Chinese ship in Reed Bank. How do you view this latest development, Paul?
Well, first, it's clearly a violation of international law by the Chinese. And it is complicated. That is, the violation is compounded by the fact that China appears not to be taking any legal action against the perpetrators of this aggressive act, nor, to my knowledge, has it offered to compensate the Philippines for the damage caused to the Filipino fishing vessel. So these are clear violations of international law by the Chinese side. I should point out that Reed Bank, which is approximately 100 nautical miles off the coast of Palawan, lies plainly within the exclusive economic zone and the continental shelf of the Philippines. So the Philippines has the exclusive right under international law, particularly the United Nations Convention on the Law of the Sea, to the resources in these waters and under the seabed. At the present time, we're talking about a fishing boat. The Philippines has the exclusive right to the fish, within its exclusive economic zone, which extends considerably beyond Reed Bank. So the Chinese vessel interfered with a Philippine vessel within a zone that belongs exclusively to the Philippines. And for that reason, it is a clear violation of international law and the rights of the Philippines. This was firmly established in the arbitral award to which you referred before, the arbitral award of 12 July 2016, which clearly established that the Philippines is entitled to an exclusive economic zone out to 200 miles from the coast of Palawan. And these waters and this continental shelf clearly fall within that area.
Paul, China says that the Recto Bank or the Reed Bank incident was an ordinary maritime traffic incident. How would you react to this?
Well, first of all, there is another international convention on maritime safety to which China and the Philippines are parties. And the reckless behavior of the Chinese vessel and the failure of the Chinese Coast Guard or Chinese authorities to take any action in response to this would be violations of that convention. So it's not simply a violation of UNCLOS, although that would be bad enough. It's a violation of another convention on maritime safety. You may recall that in the arbitral award of 12 July 2016, there was a finding by the arbitral tribunal, a unanimous finding, that when Chinese vessels interfered with and threatened Philippine fishing vessels in and near Scarborough Shoal, that constituted a violation or a set of violations of the Maritime Safety Convention as well. So it would not be the first time that China would have violated that convention by its reckless or dangerous actions in respect of Philippine vessels.
You said a while ago that the Chinese vessel interfered with the Filipino vessel. Why did you use the word interfere, given the facts that we know as of now?
Well, I could have used a different verb like rammed or injured, but I used the word interfere because we're talking here about rights, the exercise of rights by the Philippines and Philippine nationals. So it interfered with the rights of Philippine nationals who were fishing in this area by by damaging the vessel.
A while ago, you also said that China has not offered to compensate the Filipino fishermen. In cases like this, in different cases around the world, how does it usually happen when a ship, let's say if there is an accident involving a ship, is there an immediate offer of compensation, and how immediate does it happen? Can you walk us through the process, the protocol?
Well, of course, every incident has its own facts. And so what would happen would depend on the facts and the extent of state responsibility. If this is an accident by on the high seas, for example, beyond 200 miles from any state's coast, and two private fishing vessels, one from one nationality, the other from a different nationality, if they collide, whether one is at fault or it's just simply an accident, that's a matter between the two private parties. It doesn't necessarily involve state responsibility. But in this case, given the protection that the Chinese Coast Guard has routinely given to Chinese fishing vessels, particularly when they illegally enter Philippine waters, there would be a very strong case for state responsibility. That is, for China itself to be held liable for the damage that was caused and for the intrusion into Philippine maritime space. And the liability would extend beyond the owners or operators of the Chinese vessel that was responsible for the harm. So in such a case, one would expect that there would be diplomatic consultation between the two states whose nationals were involved in the incident. Perhaps there would be an effort to clearly determine what the facts were and what the damage was and the amount of the damage. And there would be a negotiation leading to appropriate compensation. That's the way it would work in a normal circumstance.
Paul, one of the defenders or advocates of the West Philippine Sea, Justice Antonio Carpio, said that it is likely that the Chinese maritime militia is behind the Reed Bank incident. Do you agree, Paul?
I think it's very likely. I think that Justice Carpio first of all, he's a world-renowned expert on law of the sea, and he's a very serious and responsible lawyer and judge. I would have confidence in his opinion.
Paul, recently, President Duterte said that he had an agreement with Chinese President Xi Jinping to allow Chinese fishermen in the West Philippine Sea. What's your comment on this?
Well, first, we start from the legal rights of the Philippines. The Philippines has the exclusive right to access the resources, including the fish, in its exclusive economic zone, which extends, as I said before, to a distance of 200 nautical miles from the coast of Palawan. The Philippines, as a sovereign state, has the right to permit other states to fish in its exclusive economic zone. what is most important here is that it is up to the Philippines, in the exercise of its sovereign discretion, to decide whether to allow Chinese fishermen or fishermen of other nationalities to fish within its exclusive economic zone. If the Philippines government makes a decision to allow Chinese fishermen to fish in the Philippines exclusive economic zone, that is the right of the government of the Philippines to make that decision. But presumably, it is a right that is extended under certain conditions in certain areas for a certain length of time, rather than a permanent license to fish anywhere and to take any amount of fish that the Chinese fishermen want to extract. So it is the right of the Philippines to give licenses, if you will, or permission to nationals of other states to fish Philippine waters.
Just to get it clearly from you, Paul, does the Philippines need to seek permission from China for its fishermen to fish in the West Philippine Sea?
Oh, absolutely not. The Philippines has the right under international law, under the United Nations Convention on the Law of the Sea, to have exclusive rights to the fish within 200 miles of Palawan. And my understanding is Reed Bank or Recto Bank is approximately 100 miles off the coast of Palawan. So this is well within Philippine waters. That right of the Philippines was confirmed unanimously by the arbitral tribunal that considered that very question and issued its ruling, as you know, 3 years ago, and confirmed that under the UN Convention on the Law of the Sea, the Philippines has exclusive right to the fish or even to the undersea resources, any oil or gas that might be there, out to a distance of 200 miles. It doesn't need the permission of China or anybody else to exercise its sovereign rights in this area.
Paul, President Duterte recently said that he reached an agreement with Chinese President Xi Jinping so that Filipinos can be allowed to fish in Scarborough Shoal. How would you view this agreement to allow Filipino fishermen to fish in Scarborough Shoal?
Well, in the first place, Filipino fishermen have the right to fish in and around Scarborough Shoal without a need for an agreement by China, without China's consent. They have that right under international law because they have fished in this area traditionally over a very, very long period of time. And under international law, fishermen acquire what are called traditional or historical rights to fish in their traditional fishing grounds, even if the area falls under the sovereignty of another state. Now, and that was confirmed by the arbitral award in the South China Sea case. The arbitral tribunal found unanimously that the Filipino fishermen who had been fishing at Scarborough Shoal enjoyed traditional historic fishing rights under international law, and that China was in violation of its obligations under international law by depriving those fishermen of access to their traditional fishing grounds at or around Scarborough Shoal. Now, that's the first point. The second point is that as a practical matter, China appeared to be willing to violate its obligations under international law and to deprive the Filipino fishermen of their rights. Faced with that situation, the government of the Philippines had to make a very difficult decision. It could have simply insisted that China comply with its obligations under international law and respect the rights of the Filipino fishermen in and around Scarborough Shoal. But if China were to persist in violating international law and the rights of the Filipino fishermen, then the government had to make a difficult decision. Should we simply keep insisting on our rights, even though the result will be that China will not allow these Filipino fishermen to fish in their traditional grounds? Or should we seek to make some sort of agreement with the Chinese for the benefit of these Filipino fishermen? And that's a very difficult decision for a government to have to make. But it is the sovereign right of the Philippine government to make the decision that it considers correct. So I think it's very difficult for me to criticize that decision.
What about the proposed joint exploration of the West Philippine Sea, a joint exploration between the Philippines and China? What's your take on this?
Well, we start from the fact that the Philippines enjoys exclusive rights to the resources within 200 miles of its coast. And again, we've already covered the point that Reed Bank or Recto Bank falls within this area of exclusive jurisdiction, of exclusive sovereign rights of the Philippines. So the Philippines legally can attempt to exploit the resources in this area, any oil or gas that lies beneath the seabed at Reed Bank, without anybody else's permission. Having said that, however, the Philippines, as a sovereign state, has the right to invite other states to partner with it in any exploratory activities or any production of oil and gas from Reed Bank. The Philippines doesn't need, as a matter of law, to get the permission or the cooperation of any other state. But if the Philippines decides that it wants to invite another state to join with it in exploiting these resources, the Philippines has the right to do that. But it's up to the Philippines if it wants to invite another state to cooperate with it or not.
Zooming out a bit, how would you assess how the Philippine government has used the Hague ruling so far?
Well, I start from the fact that China does not appear to be fully respecting the rights of the Philippines under that ruling, under that arbitral award, which is legally binding on China as well as the Philippines. So the question is, could the Philippines be doing more in order to safeguard and enjoy the rights that it won under that arbitral award, which China is not fully respecting? Now, in my opinion, China has been defiant. They've defied international law. They've defied the arbitral award. And China, of course, is a big and very, very powerful state. So how do you get a big and powerful state to comply with its obligations, especially if you're a much smaller and less powerful state? And the answer to me is it has to be by joining forces with other states that have similar interests in encouraging China, in pressuring China to comply with international law and to respect their sovereign rights. One would think that by joining forces with states like Indonesia and Vietnam, among other ASEAN states that have identical interests to the Philippines and that have identical concerns as the Philippines about Chinese disregard for their sovereign rights in the maritime spaces where they do have exclusive sovereign rights. China has encroached upon the sovereign rights in the maritime areas of Vietnam and Indonesia and other states. I think China is so big and so powerful that it can only be confronted by a group of states acting together. And we see that with the United States. Um, uh, why is the United States so ineffective in causing China to conform its behavior to international law? One of the principal reasons is because the policy of the United States has been to approach China unilaterally, whether it's on trade issues or on navigational rights within the South China Sea. The United States eschewed a multilateral approach by joining forces with the European Union, states like India and Japan, Australia, and other major states, major maritime powers. This was a big favor to China to approach them unilaterally. The United States divested itself of most of the influence that it might have had if it had acted with its multilateral partners, all of whom have common interests in causing China to obey international law. So I think it would be helpful for the United States to rethink the way it approaches China unilaterally. And it might be worth a similar self-analysis on the part of the Philippines to consider whether it might be more effective in protecting its rights and exercising its rights if it approached China in a multilateral fashion.
But Paul, President Duterte has decided to shelve the Hague ruling in the meantime, according to him, so that he can get more loans and grants from China. What's your take on this?
Well, the Philippines is a sovereign state. It has a democratically elected government, and it's for the government of the Philippines to determine what is in the best interest of the Philippines. Clearly, the government has the right to give higher priority to economic development and to securing, obtaining loans or other forms of financing or other forms of assistance from China. And it's not for me as a non-Filipino to criticize the government for its policy choices. One would hope that there would be a way, however, to obtain the benefits, the economic benefits from China, without minimizing the sovereign rights that the Philippines has, and that has won, and expended a lot of effort to win in the waters of the West Philippine or South China Sea. It's really up to the Philippine government and ultimately the Philippine people to determine whether that is the best policy for the Philippines or not.
Do you sometimes think or feel that your efforts went to waste?
Never, never. Let me say that, first of all, there have been very positive benefits from this. In the very least, Filipino fishermen are fishing again at Scarborough Shoal. But also, in the long run, for the long run, the law is now very clear. The rights of the Philippines are clearly and firmly and forever established in the West Philippine or South China Sea. Governments come and go, but the state survives forever. And the state of the Philippines, the Republic of the Philippines, whoever occupies the government, the Republic of the Philippines will enjoy these rights under law permanently. And the other governments may take a different view about exercising their rights, about confirming their rights, about vindicating their rights in these waters, and may decide to join forces with other like-minded states and create a much more powerful force that China will have to reckon with. Similarly, uh, China will have new leadership eventually, and um, as China negotiates its own relationship with the rest of the international community over the next 5 or 10 or 20 years, we may see an evolution in China toward a state that is more respectful of international law. Not because of a different moral vision, but because the Chinese government and, China, and the Chinese establishment determined that it is in China's national interest to strengthen a rules-based international order rather than to weaken it, because the law not only imposes obligations on states, it grants rights to states. And China may eventually determine that it has more of an interest in upholding international law than it apparently feels it has right now. So this is a judgment that will last forever and whose effects will not disappear, and regardless of what the short-term policy of any particular government might be.
Well, in international law, is it possible for a country to waive any award it won, not just by its words, but by its actions?
Well, I want to distinguish here between waiving an award, which was your question, and failing to exercise the rights that it won under the award. The arbitral award is part of international law. It is a part of international law, and it sets out the rights of the Philippines and the obligations of China. And that can't be waived. That case is over. The award is there. It's a permanent fixture in the international legal system. It's a different question whether the Philippines decides to enjoy or how to enjoy the rights that it won or the rights that it had vindicated under that award. Now, my understanding of the situation is that the government of the Philippines has not waived any rights under the award. I think it's been very careful to preserve the rights that it won under the award. It may not be exercising them to the fullest extent possible. And therefore, by not exercising them, it may be creating a vacuum in which China is only too happy to fill. So it might make it more difficult in the future to assert these rights and to exercise these rights. But they haven't been waived. The rights will always be the rights of the Philippines, and it will be up to the Philippines to decide when and how to exercise and strengthen them.
Paul, in the Philippines, there's a school of thought that the arbitral award is just a piece of paper because there's no international police that can enforce it. Can you explain to us how international law works?
Well, I will do my best. One fact has to be recognized as true. There is no police, international police, or international military force that exists that can be employed by a court or by international court or international tribunal to compel states to comply with its judgment or award. That is certainly true. However, in well over 95% of the cases, you're getting very close to 100% of the cases, states do comply with arbitral awards and the judgments of international courts. And that means even the states that feel that they have lost or been dissatisfied by the judgment of a court or award of an arbitral tribunal, comply in almost all the cases. Of course, China is an exception here in the case that most concerns us. But you have to ask, what is the reason that states comply with these awards, even when they lose? Why do they comply with them if there's nobody around who can make them do it? Why do they do it voluntarily? And the answer is because most states, the vast majority of states, understand that there is a value. It is in their own best interest to comply with awards, or judgments, even when they don't like them. What are the reasons for that? One is, first of all, the award settles a dispute, and it may be in the interests of both states to have the dispute settled rather than to defy the award and have the dispute continue to fester, to get even worse, possibly to lead to armed conflict. But there's another reason that I think is equally, if not even more important, is the question of soft power. That is, the influence that states exercise, not because of the size of their military or the number of weapons that they have, but because of the authority with which they speak when they attempt to influence other states. States have more influence when they are seen by other states as being law-abiding, as following the rule of law. When one state attempts to get another to honor its legal obligations or to change its behavior to bring it into compliance with international law, the state that is making that request has more standing and more influence over the state whose behavior it's trying to change if it is seen as a state that itself respects and complies with the rule of law. We see this manifested in a number of ways. States, when they act, even when they act in ways that we might consider illegal, they attempt to justify their actions as complying with international law. That's even true of China. China has invented this elaborate theory to attempt to justify its defiance of the arbitral award on the basis of international law. Of course, those arguments are completely wrong and unjustified. But what's significant is that China doesn't simply say, well, we don't like this award, so therefore we're not going to respect it. China says, no, we think the award is at odds with international law. We think international law favors our position. Why do they go to the trouble of doing that? It's because they consider it important in their own national interest to present themselves to the rest of the international community as an upholder, as upholding the rules-based international order. Now, and then there's the third factor, the third reason, which I alluded to earlier in this interview. And that is, international law protects everybody's rights. Now, at some point, China may feel that the United States is violating its rights by the way the United States is deploying its forces in the South China Sea, or near the East China Sea, or close to the Chinese coast. How will China oppose the behavior of the United States? It will make a strong case that the United States is violating its rights under international law. Now, for China to have credibility in criticizing others for their failure to comply with international law, it needs to demonstrate to the international community that it itself respects international law. So this is why most states, the vast majority of states, comply with international law, international judicial judgments, and awards of arbitral tribunals, because they have a very important interest in doing so. And I do not rule out the possibility that there will be, over time, 5 years, 10 years, 20 years, a change in attitude in Beijing. And what is important is for the Philippines to stay the course, not to give up its rights, not to lose hope, but to persist in its demands that its rights be respected.
Paul, many people are of the view that big countries are just after military might and economic might. Why does reputation matter to them?
Because not every conflict situation can be resolved by military might or even by economic might. In fact, military force is a very blunt instrument. You don't want to perform surgery with instruments that aren't sharp or fine-tuned. And using military force or threat of force carries great costs. You have to be willing to back up the threat. We see this now between the United States and Iran. The United States is not going to have much influence over Iranian behavior by threatening force. It's using sanctions. But even there, although it's causing a great deal of pain in Iran, it doesn't appear to be changing Iran's behavior. So even the most powerful states in the world can't get other states, even smaller and less powerful states, to do their bidding by threatening or even using military force or economic might. Certainly not all the time. And the reputation, the soft power that states can exercise based on the degree of influence they have, based on working together in a multilateral coalition, is often more effective in changing other states' behavior than these kinds of threats. You know, it's a classic little piece of history, although it's become quite a cliche, with Stalin questioning the power of the Vatican by saying, how many divisions can they deploy? Well, none is the answer. But is the Vatican, is the Pope without power to influence, is the Catholic Church without power to influence the behavior of states, even the most powerful states? That question answers itself. It's not always about military might or the willingness to impose economic sanctions. And states recognize this. States recognize this.
Paul, I'm just winding down. You're known internationally as the giant slayer. You won this case representing Nicaragua against the United States in the 1980s. 3 years ago, when we won this award, how did you feel?
Well, let me first say that thank you for the compliment, but it's not entirely deserved. In each of these cases, I was part of a much larger team of outstanding lawyers, and also states that were governed by statesmen with vision and courage, and they deserve the credit for winning these cases. I'm very glad, I'm very proud that I was able to play a role, both in Nicaragua's victory against the United States and more recently in the Philippines' victory over China. How do I feel about this? Well, Um, no, I've always been guided by a passion for justice and a sympathy, uh, a sense of solidarity with those who are bullied uh, by others, by bigger forces, and whose rights are abused and trampled on and disrespected. And I've tried to pursue a career uh, that allows me, gives me the opportunity or the honor of representing those who have been oppressed or victimized by much more powerful neighbors, and to provide an opportunity for those smaller states to confront their oppressors in the only place where they can confront them as equals, and that's before an international court or an international arbitral tribunal applying the law in an even-handed and objective and fair way. That I've devoted my career to that that mission, if you will, and that's what I will be doing for the rest of my life.
Paul, a while ago you mentioned your advocacy for justice and for solidarity and for siding for those countries that are bullied by others. For my last question, what do you think did the Hague ruling, the Philippines case, contribute to this bigger fight for justice for countries that are bullied by bigger nations, Paul?
Well, as I have said before, I think you have to look at it on three levels. One is the specific level of the Philippines versus China. And as I said, the rights that the Philippines won are permanent. And the lasting of the effect of the arbitral award will be forever. And it will be up to the Philippines government and Philippines governments to come to determine how successful the Philippines will be in taking advantage of the benefits of that award. On a regional level, which is the second level, this was a great victory, not only for the Philippines, but for other states such as Vietnam and Indonesia, and other states in the region that depend upon the rule of law and respect for the rule of law for their survival, as well as the enjoyment of their rights. Singapore, Malaysia, and others in the region are equally gratified by the award in this case, and are in a much stronger position vis-a-vis China as a result of it. And then there's the third level, or the wider level, the international community as a whole. This award clarified a number of issues of interpretation of international law, particularly the UN Convention on the Law of the Sea. And it is another example of holding a great power accountable under the rule of law. It has been applauded around the world. Australia, India, the European Union, many states in South America and in Africa. It strengthens the rule of law. It strengthens the rules-based international order. And this is to the advantage of the entire international community, but particularly the smaller states that need the protection of international law to avoid the violation of their rights by more powerful neighbors. And this is, as I said, the award is a permanent feature in the international legal system now, and it has had its effects and will continue to have its effects worldwide.
Thank you very much for joining us, Paul.
Great pleasure, always a great pleasure. to be interviewed by you, Paterno, and by your wonderful organization, Rappler. I wish you continued success in your efforts to bring the news in a fact-based, objective way to the Filipino people and around the world.
Thank you, Paul. We've been joined by Mr. Paul Reichler, the Philippines lead counsel against China. I'm Paterno Esmaquel. Thank you for joining us.